Remind me when LeBron was in trial. It was so much that you could say, like, man, this man's supposed to come home today. But that ain't how the courts work. They got some others. You can see them. But yeah, it's Atlanta. You can see the others too. I'm looking at them now. Yeah, they've been showing them. They trying to make it like it's a closed court and everything. Which means he cooperated right there. That's behind him.
The beauty of Holland delivered directly to your door.
Plenty of Europeans in there when you're watching the video, man. He looked like a retired police officer himself, his attorney. Let me call Barnes Hill back, see what he wants. Islam is all I can say. He yarning. He ain't taking this serious. Brother Chairman. You say he a good attorney though, babe? What he do, all criminal work? So you don't know, you just know he good, The judge seemed like he impart, like 1 minute he there, next minute it seemed like he just don't know what to say or do. The judge. He a dirty judge. You should be breaking this whole case down. This your thing, law. Law. What up? You order us coffee, Empress? I'm out.
I don't think the state wanted the entirety of the statement as well. But I believe that under U.S. versus King, that's what they're saying, or they're asking the court to play his statement for that purpose. So
play a statement.
To that extent, I'll let it be played over your objection. I'll give you continued objection on that issue, okay? All right. Mr. Sharp?
Yes, sir. Yes, Your Honor. Three things. First of all, we still haven't gotten we're all referring to this U.S. v. King. We still haven't received a citation for it. So I don't know who's been able to review it. But we need a citation for that.
Ms. Hilton, you want to give us the citation again? It's only a Westlawn Lexus site, is that right?
93.
It's a lot of our people in there, though.
845.
I know.
F 4th.
845.
845.
Yes.
All right, next.
Okay, second, Your Honor, I just keep going back. We're talking about exposing the jurors to a plethora of information that's not admissible under the rules of evidence, and then just suggesting.
What rules of evidence are you talking about? What are you saying is not admissible?
Statements that are not inconsistent.
We've gone through that already. This is about the 4th time from you, and I understand that.
There's a mechanism.
You're not waiving anything, but
There's a mechanism.
Why are you trying to get down on him?
Just ask investigator 830.
but they don't choose to do it that way, Mr. Sharp. We're going to just disagree on that.
Okay.
And so that's number 2. Okay.
See this, Brother Chad?
We have so many versions of this tape now. Excuse me.
Which tape are you talking about? The August? Okay, all right.
We have so many versions.
So many versions.
I have in the complete version.
So many versions.
10403 to 10419. So I don't know what the time frame is on the redacted version. Mr. Murphy explains to Investigator Dennis how different members within the crew, I believe,
Different members.
About the YSL crew,
Conspiracy.
have their own gang backgrounds.
Conspiracy.
Somebody Crips. Therefore, there is sometimes a bit of an in-house competition. Mr. Murphy says he believes Shannon is the most on the go because he believes Shannon wants to prove himself to Mr. Williams without letting other members, specifically Crip members, get all the
Crip
credit.
members. So Crips and Bloods.
This dynamic exists even though
In Atlanta.
within YSL. That is a lot of speculation. That is also bad character evidence. I don't know. Again, we've gone back and forth with suggestions. I don't know if that was previously flagged, but I have it as 10403 to 10419 on the original recording. I believe that would be completely inappropriate to play in front of the jury. It's not inconsistent with anything Mr. Murphy testified to, and it also runs afoul of other rules of evidence. And so, however the state is silencing or redacting when they're planning on playing this tape, I would ask that that specific passage be redacted as well.
Ms. Hilton, Ms. Love,
Yes, Your Honor. We asked specifically Mr. Murphy on the stand. I think I even asked him, what does on go mean? I believed I asked him, who is the most on go? And he said, I don't know what you're talking about. I don't know what you mean. And so, Your Honor, that statement will be direct contradiction, impeaching him by a prior inconsistent statement. What he says is based on his observation, who is the most on go. So that's not speculation. That is, in this interview, his observation of who is the most on go out of the crew. And that is what he was asked and what he said based upon his relationship with the parties. This is something else we have to prove in the conspiracy. It's his party, it's his crew, and he made an observation.
She trying to make him head.
His relationship with individual members of his gang. And it shows the existence of the enterprise, Your Honor. And so that is something we have to prove. That's something I specifically asked him in court. He denied it, and therefore the state believes we can play his statement that he gave to police when his gang members weren't in the room with him, when he was by himself with his police, with the officers, and with his counsel.
Your Honor, they cannot just bootstrap wholly inadmissible, prejudicial, bad character evidence in just by asking about the statement previously, it being denied.
Facts.
Okay, now we get to play it. Like, if Mr.
What
Murphy
you said, she.
Joe is a murderous maniac who killed 5 people in Iowa, that would be wholly inadmissible. can't just say, didn't you say Joe was oh no, I didn't say anything about Joe. Okay, now we just want to play it. It has to have a basis in admissibility. And they're just trying to say everything's a prior inconsistent statement, and if it's inconsistent to what he testified before, automatically it's in. That's not the way the law is.
No, it's impeachment. It's impeachment by contradiction.
But Your Honor, just because
as well.
it fits into one rule, if it's inadmissible under other rules,
Well, that's why I rule on things. I mean, so yes, I understand that.
Okay, well, how is this bad character evidence against Shannon Stillwell being entered into this case just because?
It's not. You may think of it as character, but it goes for another purpose, and that's to put the stage as told you.
And Your Honor, when I'm looking back at the transcript, I believe this is the transcript I sent over to Mr. To everyone. Matter of fact, the state actually redacted that portion. It stops at who's the most on go with the crew, and Walter Murphy says Shannon, and then we stop it there.
But she was weak during the whole trial, though. To me, she was asking like gang questions and drug questions.
Similar to Mr. Steele, I'll note your objection. Okay.
Okay, thank
All right. Thank you, sir. All right. And then the last thing the court has to go through is, and I will, Mr. Steele, to your August 18th redactions and the email that accompanied those. As well as the July 15th statements that you included in the email you sent on 4/2024 at
4/20/24.
Email attachment says that next court's exhibit in order as requested. And I'm also in possession of Mr. Williams' motion to strike purported expert Gaither's testimony and to prevent any additional expert testimony from supposed gang experts from the city of Atlanta Police Department. That was sent via email. I'll also include at yesterday evening at 10:17 p.m. It also references in the motion, and I'm going to quote Mr. Williams, a portion of Mr. Williams' paragraph number 5. Basically, the lack of a pretrial Daubert hearing. No report, expert report, no CV, the CV being provided.
It's a hard case for him, babe.
And a pertinent part, I'll quote, Mr. Williams shows not the questioner because it was already a fake conflict.
You can see it.
That this honorable court found
Shut down everything.
somehow testifies an expert in
Yeah.
known fields. I will acknowledge that I did study French, and fait accompli isn't used very much. It is something that has already happened or been done that you cannot change. So I'm going to also cite Mr. Steele. I mean, I know that you're not saying that I said that, or I basically that my conduct inferred that, because I would remind everybody about Rule 3.3 of our Georgia Bar Rules, which is duty toward the candor toward the tribunal. Lawyers shall not knowingly make a false statement of material fact of law to a tribunal. I'm also going to include a portion of the transcript, which which I was able to get from Ms. Weaver, which I'll include as the next sports exhibit in order. I'm deeply disturbed that you're taking what the court did out of context. I understand that you all are attorneys, but I want to just remind you about just you all's candor to a tribunal is first and foremost. Mr. Wine, I'm going to quote from Mr. Weinstein, who before Detective Dennis testified. I understand that investigator Gaither is going to be used as an expert witness. It's also my understanding that yesterday the court found here to be an expert witness already, her to be an expert witness already. The court, no, I have not. Mr. Weinstein, did you not say that yesterday? The court, no. She's going to be qualified as an expert. Mr. Weinstein, you didn't find her qualified yesterday? The court, no. She'll go through the same establishment of issue. Were you here yesterday? No, you were not. You weren't. Okay, so here's the way it goes. The state is going to qualify her. There's no requirement for there to be a pre-admit hearing for that. Your colleagues attempted to ask me to do that yesterday. I was not of the opinion to do that. Mr. Weinstein, would the court be willing to qualify this expert prior to the jury coming into the courtroom? The court, no. Mr. Weinstein, that's the way, in my experience, it is. The court, no. Mr. Weinstein, always been done in federal court. The court, it can be done. There are some 11th Circuit cases I was shown yesterday that authorized for that. So, Mr. Weinstein, I understand that you may be authorized to do that. I was suggesting that the better practice may be to do that before the jury is present. The court, Mr. Steele asked me that yesterday. Mr. Weinstein, thank you, Your Honor. The court, I am going to see if they qualify the witness using the Dahlberg standards and 702, and we'll let you all voir dire the witness accordingly. And then I will make a decision as to whether or not a particular individual is able to testify in that manner. Mr. Steele, Your Honor, can I just get a continuing objection? The court, yes. Mr. Steele, I believe the case, the 11th Circuit case is where. The court, you're right, it is where. Thank you. Where I don't believe it says that in front of the jury. And if it wasn't done at all, you have discussion to find someone. No, it wasn't, but there was no pre-admission. It was done in front of the jury because of the type of case it was. I think it was a firearms or ballistic or whatever else. And Mr. Steele, I think the court just made that finding anyway. I'm objecting to it in front of the jury. I'm objecting not to having a Dahlberg hearing outside the presence of the jury. So, state, lay the foundation for Detective Dennis to testify as an expert. The court also read the admonition as to an expert and fact witness before this witness testified. I gave all of you the opportunity to voir dire the witness before the court made a determination of whether or not she would be tendered and qualified as an expert. None of you took the court up on that because up to that point in time, I had not ruled that she could be qualified as an expert. So, Mr. Steele, I'm in possession of your motion. I don't believe it's timely. I believe it's waiver. I believe you still have the opportunity to cross-examine Detective Gaither about anything that she may have in terms of her.
Deny every motion they put in.
Every motion?
So for that reason, I'm going to deny the motion at this point in time.
Look, he said he's going to deny that one too.
You may have two.
Your Honor, I believe that the court is misunderstanding the sequence in paragraph 5 of my motion to strike Detective Gaither's testimony. The sequence is as follows. Court, outside the presence of the jury, I believe the night before, maybe early that day, I don't remember exactly what you just read. It denied outside the presence of the jury,
I did.
Then what happened is...
And that was because where allowed, or in the court's estimation, even though we may disagree, I believe that gang expert testimony and this particular witness's background would lead her to be qualified. But the state still had to do that in front of the jury for me to make an expert determination.
My understanding where I understood it is different. Court made that determination without the hearing, and then it,
Which I didn't need to do, and you all disagreed. I get it.
so, anyway, the way then sequentially, this honorable court, as Detective Gaither was about to testify, gave that instruction, which you gave 2 times previously, about Detective Belknap, saying that this is a dual witness. I don't have to repeat it, I presume you know what I'm talking about.
Yes, sir.
Experts. When you did that, and then the state is qualifying Detective Gaither, I, Brian Steele, stand by, I'm not accusing this court, and I'm certainly candid, always got will with the court, but I took that as.
No, but that wasn't. You had the right to voir dire the witness before the state proffered her or accepted. The court said she was an expert. You had the opportunity to fully examine her, because you know what would have happened if they would not have qualified this witness pursuant to Daubert and 702. I would have excluded her. You would have probably moved to have her excluded as a witness, an expert witness, which I would have granted. But that didn't happen. And I asked all of you whether or not you wanted to take advantage of that. So
What I'm trying to say,
you waived that issue at that point.
They say fire the judge, get him up out of there. He's not fool.
But why didn't you do it? I mean, because you could have done that, and that was the danger for the
You
state
could've.
asking me to do that.
Would've, could've, should've.
Because
Looking
had
at.
they not gone ahead and qualified that witness, they would have fallen flat in front of this